our contention is that this Honorable Court Martial has no jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. It's a consolidated constitutional petition number 55 and 56 of 2011. But Mr. Chairman, here reference was made to a number of decisions that have been taken by other Commonwealth countries, which we find to be persuasive. First of all, Mr. Chairman, they made reference to the case of Regina versus Horsefeld Road Magistrates Court. It's 1994, SC, Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they had to say. English common law regarding irregular apprehension of an offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Horsefeld. The earlier approach of the English courts had been that once a suspect is in lawful custody in that country and charged with an offense which that court has jurisdiction to hear, the court has no power and is not concerned to inquire into the circumstances in which he may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or kidnapped contrary to the laws of the state of refuge. That was the jurisprudence and the practice at then. And the House of Lords had to reverse that position, and this is what they had to state, which is now the common law position on issues to do with the people picked from other jurisdictions and tried elsewhere. That whatever differences there may be between the legal systems of South Africa, the United States, New Zealand, and this country, many basic principles to which they seek to give effect stem from common law roots. There is, I think, no principle more basic to any proper system of law than the maintenance of the rule of law itself. When it is shown that, and this is the principle, when it is shown that the law enforcement agents responsible for bringing a prosecution has only been enabled to do so by participating in violations of international law and of the laws of another state in order to secure the presence of the accused persons within the territorial jurisdiction of the court, I think that respect for the rule of law demands that the court take cognizance of the circumstances. To hold that the court may turn a blind eye to executive lawlessness, it would again appear to me to be a wholly inadequate response for the court to hold that the only remedy lies in civil proceedings against the individual offenders of the law enforcement agents who are concerned with the illegal actions taken. And this was also reinforced, Mr. Chairman, in the case of it was reinforced, Mr. Chairman, in the case of in the case of State versus Ibrahim, this is a South African case. The citation is there, where court held that we also consider established the principles that a court has no jurisdiction. Allow this. Stand up after Mr. Chairman. We also consider established the principle that a court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of the jurisdiction of the court. And that abduction, kidnapping, represents a grave contravention of international law, the Committee of Nations, and the rule of law generally. They made reference to the aforesaid case of Regina also. We observe that courts in this country have scrupulously reaffirmed the need to observe the rule of law and prevent the abuse of the court process. The case of Dr. Besigye versus the Attorney General Supra has held that this court is obliged to intervene and even stay proceedings where the abuse of the court process is such that no fair trial can be achieved. This principle was reaffirmed by the Supreme Court in Besigye and others versus the Attorney General, Constitutional Appeal number 1 of 2006. This is the position the Constitutional Court adopted, one in Dr. Besigye's case, but also the position that has been well established in all Commonwealth countries or jurisdictions, that once the accused persons are illegally brought before court in violation of international law and they have been kidnapped and illegally extradited, then that court has no jurisdiction to deal with the same. We are making reference to the Extradition Act, a copy of which, Mr. Chairman, I'm sure you have, which clearly makes provisions on how accused individuals or citizens of a particular country, Ugandans, who are alleged to have committed offense outside the country, are supposed to be transferred back to the country where they should be charged. One, this Extradition Act, Mr. Chairman, talks about a fugitive criminal, that one must have been a fugitive criminal to be subjected to extradition. It's abundantly clear that at no one moment has this court-martial been presented with a record that prior to their production before this court, that they were criminals, they were fugitive criminals who had pending charges that required their extradition. And even if that were to be the case, Mr. Chairman, the Extradition Act provides for the procedure on how this should be done, which involves the judicial process, that you go through the processes of the judiciary in Kenya, where they were arrested from, present them before the law, a warrant is made, and upon a request made by the domestic minister here to the counterpart in Kenya, requesting that commence the process of extraditing that fugitive criminal who is within your territory, your jurisdiction. That is what is provided for in the Extradition Act, which we have here. This was never the case. There were no extradition proceedings in Kenya, and therefore they were not legally transferred back here. The other option would be the